أعوذ بالله من الشيطان الرجيم بسم الله الرحمن الرحيم نحمده ونصلي على رسول الكريم. Last time we had left the discussion at the point where I had said that basically in broad terms, there are two systems of heirship in the West, particularly, that is the civil law system, and the common law system. Uh, in the civil law system, there is a forced heirship, as in Islam, that one cannot dispose of the entire property, all the property, by his will or by his terms, but he has to leave something to share for sharing by the inheritors. But under the common law system, one can dispose of all the property. So in that context, we had discussed that there is indefeasible portion, that is it passes to the next of kin, but in Islam it is more detailed, and it includes various categories, and the discretionary portion one can dispose of under the will. So in Islam, it is distinct. There is a distinction. The portion which one can dispose of through the will, and it is by the practice, by the sunnah of the Prophet, peace upon him, limited to one third. And the remaining two third goes to the heirs as fariza. I think we have not discussed this word fariza. We have been just discussing other things. But now, when I'm using this word, this has occurred to me. Fariza, who's Fariza? Which is Fariza? What is Fariza? It is Fariza for the inheritor, or it is Fariza for the person who is leaving the estate, who is dying, who is leaving it. So this is a very important point. That is why I had said in a different context, not while discussing Fariza, that the shares in Islam which we inherit are not just a right. Because of this concept, there is a responsibility also. So when we come to that again, if we come to that again, we will discuss it again. So anyway, we have discussed these two parts, these two portions, and now we are starting discussion going further from this point. I just reminded these 2 points that from where now we are picking up the thread. Distribution of estate to persons who were not in legal marriage. This is very important for those who are living in the West, who are living in America, particularly the younger generation. They don't understand the legalities, the legal implications of these things. Distribution of estate to persons who were not in legal marriage. And in case of same-sex marriage, it is more, and it is becoming every day more complicated. Forced heirship in civil law legal systems, for example, in France, do not recognize total freedom of testation. For example, in Islam, one doesn't have all the freedom to dispose of everything. In contrast with common law jurisdiction, for example, in England, in UK, in the countries which were colonized by England, there one can dispose of all the property. Now, types of wills. Not all, but there are a couple of the points which are very important. Non-culpatory, oral or dictated, limited to military personnel. This is particularly a will which is allowed that the military people, because they are at the borders, they are in the war, they die during the war. So they have been special arrangements for non-culpatory, oral, dictated wills which are limited to military personnel. If there is somebody in military, he should understand non-culpatory will. Holographic will, the entire will is written in hand of the testator. And I know some many friends in Houston who have written their wills in their own hand. Now, what is it? It is written in hand of the testator. Traditionally, it has to be signed by witnesses. Although uh, the will can be made orally, it can be dictated, and it can be written down. Depending upon the circumstances, if the witness is not available, even then, in the probate proceedings, the court can establish the truth of the will, that this is correct. But it is generally required where there is a possibility, where it is convenient, where there it is available, that the will has to be signed by witnesses attesting to validity of testator's signature and intent. Only signature is not sufficient, and only intent is not sufficient. Both these things are very important. The intent is also proved from the will. The person had the intent to make that will. Testator must have had intellectual capacity to will. It is if it is proved that at the time of death, for example, the person has already entered the phase of clinical death, the person has become unconscious, semi-conscious, or Hazar al-Maut has already arrived. In these situations, the intellectual capacity is always determined by the court. Here, it may uh, perhaps be relevant to understand. Maybe it was one of the reasons that Hazrat Umar did not allow the will to be written at that time, even though the Prophet had asked for paper and ink, or somebody was called to take the dictation. The longest will was of some person, Cook. His name was Cook in 1925, 1,066 pages, and it was only for $100,000. The shortest will ever, it has been only 3 words. These are reported in the Guinness Book of Records. And there is yet another will which comprises of just 1 or 2 words, hairs, because he had no time to write. This is the will which I have highlighted it in red color. I personally recommend this type of will. There may be different types of will, but this is the one I recommend. What is this? This is in solemn form with affidavits of subscribing witnesses to avoid probate. The purpose of the will, as we find from ayat number 282, and at some other places in Quran, that everything should be written, which has futuristic effect, which has financial effect, which has fiduciary effect, should be written down, and it should be witnessed. The purpose is that the written document should be complete in all respects, and Allah subhanahu wa ta'ala has made it clear in different ways, so that one does not have to go to the court after the death of the person. And even if there's a need to go to the court, then it's still not complicated for the court to prove it, to go into details and call for more evidence and more witnesses. So it should be self-proved, so that there's no need of going to the court or going for probate. Now, for that, whatever we have discussed so far, you can recollect that what has to be done, how it has to be prepared, what precautions I should take, how I should be careful, everything, this type, self-proved will, every intention, everything is proved there, then and there in the will. Then notarial, it should be notarized, not necessarily legally, but better. Then mystic will, that is, it is sealed until death. Nobody knows about it until the person dies. It is deposited usually in the court, in the county, with the clerk of the county. Then serviceman's will of person in active duty military service, reciprocal, mirror, mutual, husband and wife will. At one time, a question was raised about this also, and I had said one can write a joint will, one can write this one, this reciprocal will, one can write as a joint will, but it is better to write, even if one is going to write the mirror, one is going to create a mirror of the will, husband is creating the mirror of the wife's will, or the wife is creating the mirror of the husband's will. They can create a joint will, but it is better to create separate wills. Even if these are mirror, but it is better to create each will separately, so that when if the matter goes to the court, the one is not held up because of the probate or the court proceedings of the other. Unsolemn will, executor is not named. If it is not named, it will go to the court. It will be treated as unsolemn. The court will appoint the executor. The solemn will, the form signed by testator and witnesses. Solemn will, it is like a proved, this one which I mentioned here, self-proved will, so that everything is proved from the will. Now, what should be the content of the will? Required content varies. It can vary from one person to the other person. Therefore, many times it is better that the husband and wife, they create their own will separately instead of only creating a mirror will. Because by the time of the death, in both the cases, one dies early or one dies afterwards, or there may be other circumstantial changes. And at that time, the mirror may be a problem. The circumstances change individually. Individually, they change, the circumstances change. So, the content of every will, each will individually may vary. And it has been seen that it varies. It varies necessarily. Depending on jurisdiction, this also depends on jurisdiction. For example, if the wife has prepared the will for a property in Houston, and the husband has a property, say, in Egypt, and he prepares a will for his property in Egypt, he cannot create a mirror will. He should. It is advisable to create a separate will, depending upon the jurisdiction and depending upon the circumstances on the property. But anyway, it includes these points. One is the publication, in which one declares, identifies himself that I am the maker of the will. I am making the will. And it is important to write the last will and testament on the face of the document. The word last must be written. Otherwise, and particularly when the date is not there, then any will may be claimed to be the last will. And therefore, it is very important to write the date and also write the word last will and testament. Testator should declare that he revokes all previous wills and codicils. What is codicil? Codicil is if any partial or in part amendment has been made in the will, or any change has been made in the will partially. That is codicil. Revocation is when the entire will is changed. That is revoked. Testator should declare that he revokes all previous wills. If he doesn't declare that, even if they remain in force, generally, I'm repeating the word generally, the last will, which is proved from the date that this is the last will, it will revoke all other wills. But in many cases, on legal grounds, there are many legal grounds, and there are there can be valid legal grounds where one may be able to prove before the court that although this is the last will, but this does not fully revoke all the other wills which were written before. They partially or otherwise, in certain cases or some respects, they override that or they revoke it. Therefore, in unequivocal terms, very clearly, it must be mentioned. I'm emphasizing these words very clearly because many people make these mistakes when they come to discuss the things they usually don't know about these things. That the testator should declare that he revokes all previous wills and codicils. He must write this in the last will. A subsequent will revokes earlier wills and codicils only to the extent which they are inconsistent. If they are not revoked, for example, the last will, if it is proved from the date that this is the last will, it will revoke all other wills which were made before, previously. But reread this portion. They will revoke this only to the extent which they are inconsistent. If they are consistent, they will not revoke. That is why I said there can be many legal reasons, arguments that this may be challenged in the court that the last will does not revoke all other wills. For example, the person had a wife. He divorced her and he married another woman. And after some time, he dies. The last will he gives to the last wife. She goes to the court. But the previous wife, when she comes to know about it, she also comes to the court and she brings a will. Although it is the proved that the last will is with the last wife, but it's still from the language, from the contents, and from the inconsistencies, the first wife was divorced, she can still have the claim. Testator may demonstrate that he has capacity to dispose of his property. He should have sound mind and does so freely and willingly. In the will, he must write that I am doing this intentionally with my sound mind, with full consideration. I have considered it fully well. Am I making it freely? I am making it willingly. Testator must sign and date. I have already said this. Sign and date the will, usually in the presence of at least two witnesses. At least two witnesses. Here I am emphasized that it's not necessary that there should be male witnesses and they are valid only. Even a woman is valid as a witness, even as a one witness. The situation of a contract is different from the will. In a contract, there are two parties. Therefore, Allah subhanahu wa ta'ala has allowed at least two witnesses, preferably men. If two men are not available, one party will have one man, for example. There are only one man is available to one party. The other party has no man available. He can have two women. It is a relaxation. It is a concession to make the matters easy for him. But if he doesn't find two women, even one is enough. It depends upon the circumstances. Instead of making the evidence or the witnesses to fail, it is the theory of every law, every legal system in the world that the law should not allow the evidence, should not allow the case, should not allow the justice to fail. If one person at that time has only one woman available, you cannot stop her, that she cannot be. This is because of the circumstances. Who will decide? The judge will decide. Take it to the court, the probate will decide, the judge will decide that what were the circumstances, two persons or two women were not available. Therefore, the corroboration will help that person. But particularly in the case of will, where two parties are not involved, it is only one party. And he has only one person available in the family. It is not Nisa, it is Imratan. Daughter is available, wife is available, sister is available, or mother is available. He can make her the witness so that the will does not fail, so that the justice does not fail. It is important to save justice, save one's right. What is more important is not the word of the, is not the legal term, but the justice itself which has to be saved. Holographic wills entirely handwritten and signed by the stater I've already mentioned generally require no witnesses depending on jurisdiction. But there are certain jurisdictions in which they will still require that even if it is written in hand, it should be brought before the probate, it should be brought before the court to determine whether it is right or wrong. Testator's signature must be placed at the end of the will. You have seen many documents where people sign in the margin, at the top, or in the middle, but wherever you sign for correction, but at the end of the will, it must be signed. And the signature at the end of the will shows that now the contents of the will end here. And anything written after that, that is not part of the will. That may be witnesses, that may be notary, that may be anything else, but it is not the content of the will. There's no legal requirement that a will be drawn up by a lawyer. You don't need a lawyer. If you understand properly, you can write it yourself. I've shown one word will, heirs. 3 words will, all to heir. International wills. Now, this is also important for those who have multiple properties in multiple countries. And now this is becoming increasingly acceptable. But one has to understand. In 1973, International Convention providing uniform law on the form of international will, for example, in Texas, to the extent of Texas only, for Texas only, Supreme Court of Texas has devised a uniform format or template of a will. That is only for Texas. But this at the international law for all the nations, for all the countries, an international organization, an NGO you can call, they have provided, they have devised a format of the international will. The convention provided for universally recognized rules. A convention was passed, it was adopted. What is a convention? Convention is like an international law. In the countries, the law is passed by the parliament. But what is international law? The international law comprises conventions and agreements, international conventions and agreements. They together make the international law. The convention provided for universally recognized rules under which a will made anywhere in any country. But there is a caveat in this. Anywhere by any person of any nationality would be valid and enforceable in every country, that became party to the convention. If it has not become party to the convention, for example, in many other cases like International Court of Justice, some countries say we are not party to it because we have not signed the convention. Some countries have signed this convention of uniform will, uniform format of the will, but they have not ratified it. So one has to be knowledgeable on this aspect, whether if you are writing an international will for your properties located in different countries, then first of all ask, inquire whether these countries where your property is located have joined this convention, have accepted this convention, and they have ratified it, but their parliaments have ratified it. If it is only accepted, convention is accepted, but it is not ratified, there are many laws in America which have been accepted but not ratified by certain states. It is enforced. For example, these are the countries, I'm giving you the names, where the uniform format of the will is accepted. Australia, Belgium, Bosnia, Herzegovina, Canada, in 9 provinces only. In Quebec, it is not accepted. Croatia, Cyprus, Ecuador, France, Italy, Libya, Niger, Portugal, Slovenia, Holy See, Iran, Laos, Russian Federation, Sierra Leone, United Kingdom, and United States. And here you will see that some of the participants on Zoom are sitting at MRC who belong to different countries. Their names are not, the names of those countries are not here to which they belong. So therefore, they have to be careful. They have to first know which countries have accepted. Some countries have signed but not ratified. There they cannot be enforced. For individuals who own assets in multiple countries, it may be appropriate to have multiple wills, one for each country. And I have already said, better to have a single will instead of going for a joint will or a mirror will in such cases particular. And it should be self-proven. As I've already mentioned, one should be very careful that you should be self-proven. There should be no need for your heirs to go to the court. When they go to the court, then there are many other questions which they come up for discussion. In most jurisdictions, partial revocation, I have mentioned this already. Partial revocation is allowed, partial revocation of the previous wills or that will, if only part of text or provision is crossed out. For example, somebody says that I had crossed the will. This may not necessarily revoke the entire will. When these cases come to the court, there are many legal aspects which may be debated that although he has crossed it, but this does not revoke the entire will. It revokes only the part of it. So be careful. Just crossing does not revoke the entire will. You will have to write in your you will have to write it properly that you revoke the will which you made previously, all the wills before this date. In some jurisdictions, complete revocation. This is also very important. In some jurisdictions, complete revocation of will automatically revives. If you revoke a will, it automatically revives also. How and why? This is a question of law. Automatically revives next most recent will. For example, you have written a will on, say, today, this is 6th of September, and you say that you have revoked the will which you have written on 6th of September. If this is revoked, this is cancelled, then automatically the will which you had written last year, for example, that will be revived. Generally, one is under the impression that when I was writing this will on 6th of September, I have written in this that I revoke all the previous wills. But now when you have revoked the will of 6th September, it means it has revived the last will. This is a legal point. I am repeating this. In some jurisdictions, complete revocation of will automatically revives next most recent will. While in some other jurisdictions hold that revocation leaves testator with no will. For example, if you are in England and you are in America, same person, same person's property, but property located in England and located in America, he has crossed the will or he has revoked the will, but its effect in England and America will be different, may be different. At one place, they will think that he has revoked all other previous wills, and in other places, and at other place they may think that he has not revoked any will from the past, or the most recent will from the past, so that it becomes intestate. If they decide that it revokes all the wills, not just the recent will, if they decide that it revokes all the wills, it means he dies intestate. It means now the state has to decide, the court has to decide. And at this point, before I close the discussion for today, I take you back. If it is proved that the person has no will, the property, the estate, escheats. Last time I had shown you what escheats means. Escheats, it means all the property goes to the state, to the government. So these are small points, minor points. They may appear to be minor points, but they have major effect, important effect. We have to understand this. That is why I tried my best to make it simple and go slowly so that I may try to emphasize every word or every term of it. Subhana rabbika rabbil izzati amma yasifun wa salamun alal mursaleen walhamdulillahi rabbil alamin.
اللهم صل وسلم وبارك على سيدنا محمد وعلى آله وصحبه. اللهم اهدنا فيمن هديت، وعافنا فيمن عافيت، وتولنا فيمن توليت، وبارك اللهم لنا فيما أعطيت، وقنا واصرف عنا شر ما قضيت، فإنك يا ربنا تقضي بالحق ولا يقضى عليك. اللهم ادخلنا برحمتك في عبادك الصالحين. اللهم اخرجنا من ظلمات الجهل والوهم إلى نور العلم. اللهم علمنا ما ينفعنا وانفعنا بما علمتنا وزدنا علما. اللهم اجعلنا ممن يستمعون القول فيتبعون أحسنه. اللهم اكفنا بحلالك عن حرامك، وبطاعتك عن معصيتك، وبفضلك عمن سواك. اللهم بفضلك ورحمتك أعلي كلمة الحق والدين. اللهم انصر الإسلام وعز المسلمين يا أكرم الأكرمين. Oh Allah, spread your mercy upon us, shower us with your blessings, increase our knowledge, grant us forgiveness, and reward us with the company of the prophets in the Firdaus al-A'la. Oh Allah, purify our hearts, strengthen our faith, increase our knowledge, and make us benefit from what you have taught us. Oh Allah, forgive our parents and all our friends and relatives who have passed away. Oh Allah, make their graves garden from heaven and grant them the Firdaus al-A'la. Oh Allah, we have many of our friends and relatives who are sick. Oh Allah, grant to all of them full and speedy recovery. Oh Allah, guide our children, protect them, and make them righteous. Oh Allah, grant us the power and the ability that we may be grateful for the favors you have bestowed upon us and our parent, and that we may do righteous deeds that are pleasing to you. Oh Allah, we seek from you all of the good, whether we know it or we don't. And we seek your refuge from all evil, whether we know it or we don't. Oh Allah, we seek refuge in you from incapacity, from laziness, from fear, from greed, from poverty, and from the torment of the grave. Oh Allah, we have many of our brethren who are living under oppression and injustice. Oh Allah, heal their trauma, protect their helpless, and grant them lasting peace and prosperities. Oh Allah, we ask with every name you have elected for yourself, that none of us leave this gathering, but his pains have been relieved, his worries have been removed, his debts have been paid, his weaknesses have been concealed, his sins have been forgiven, and his needs have been fulfilled. سبحان الله وبحمده عدد خلقه ورضا نفسه وزنة عرشه ومداد كلماته. سبحان الله وبحمده عدد خلقه ورضا نفسه وزنة عرشه ومداد كلماته. سبحان الله وبحمده عدد خلقه ورضا نفسه وزنة عرشه ومداد كلماته. والعصر إن الإنسان لفي خسر إلا الذين آمنوا وعملوا الصالحات وتواصوا بالحق وتواصوا بالصبر. وآخر دعوانا أن الحمد لله رب العالمين، والصلاة والسلام على خير المرسلين. اللهم صل وسلم وبارك على سيدنا محمد وعلى آله وصحبه، والسلام عليكم ورحمة الله وبركاته.